Good evening, and we'll call the steering committee meeting to order. At this time, I'll call on Vice Chair Turner for the reading and approval of the minutes.
Thank you, Mr. Chairman. I've had a chance to review the minutes. I find them in order, and I make a motion for their approval.
The motion is a second.
Second.
All in favor, please say aye. Aye. Motion passes. I did receive a phone call from Commissioner Phillips, who is unable to attend our meeting this evening, so just for your information. First item on our agenda is to fill the vacancy District 19 County Commissioner seat. We do have 4 applicants. I will call to your attention that Mr. Mike Lyles is one of those applicants. He had a long-standing prior plans and issued his regrets that he could not be here this evening. He did send us a letter, and it is in your packet of information. How we will probably move forward is to hear from each of the applicants this evening. I would like to invite them to introduce themselves and talk to us about anything that's on their minds this evening. We will have an opportunity to ask questions. At this time, we do know that all of them have been certified that they are residents of District 19. The committee will have 2 options. One, we can recommend a candidate, send that candidate to the full commission, or we can send the whole slate of applicants to the full commission and let the full commission vote. That will be up to the committee, of course. Our first applicant, we would like to call on Mrs. Joyce Ely. Ms. Ely, would you like to come to the table and address the committee?
Or stand whatever.
Or stand whatever. Yes, ma'am.
Whatever's appropriate, yes.
You know.
My name is Joyce Ely, and some of you know my work and my commitment to District 19. But for those of you who are not familiar, I was first elected to the County Commission in 1990. I served until August of 2014. During my tenure on the County Commission, I served on various committees, spending most of my time on the Budget, Finance, and Investment Committee, where I served as chairman for 12 years. As I stated on my application, I consider my work on the County Commission to be my community service. And I would be honored to represent District 19 and to work with the Commission for this interim. I would appreciate your consideration, and thank you very much.
Okay. Thank you. And you said you represented District 19 at one time?
Yes.
Okay. That was one, during the restructure, it was one term on District 19?
Well,
on the new district, I'm sorry.
Well, I was going to say, no, these lines that are now are new
Okay,
lines
right.
to me. That happened
Okay.
in 2014.
I got you. Any questions for Mrs. Ely? Okay, thank you, Ms. Ely. Next, Casey Gregory.
Hello, I'm Casey Gregory. Like the other applicants, I would like to stand here and talk about my political resume, but I don't have one. But what I do have is passion for this county that I was born and raised in. I grew up and watched my father dedicate 32 years of his life serving the residents of Rutherford County at the Sheriff's Office. And now I watch my husband don his gear and serve those same residents. I grew up around public service, and I'm passionate about Rutherford County and the decisions that impact not only the residents but my loved ones as well. I never saw myself in politics, and I really still don't. I see myself serving and speaking out for Rutherford County and the residents of District 19. I'd love to be considered for this seat and bring a fresh perspective to the County Commission. As an account manager at Dispensary of Hope, my role is to partner with clinics to serve the poor and vulnerable. And through that work, the calling to serve my own community has grown. I hope that you can see the love I have for this county. I'm proud to live in Rutherford County, and I would be honored to serve on the County Commission. Thank you.
Any questions for Mrs. Gregory?
I've got a question I'd probably like to ask all of them, but I'll wait till all of them speak.
Okay, that's fine. Again, Mr. Lyles was unable to attend this evening. Mr. Brandon Thomas.
Hello, everybody. My name is Brandon Thomas. I was born and raised in Rutherford County. I graduated from Smyrna High School and graduated at MTSU. At MTSU, I represented my fellow students as a Student Government Association leader. I was also the opinions editor of the student newspaper, The Sidelines, where I worked hard to make sure all viewpoints were represented. Most recently, I ran for State House, House seat District 49. Although I didn't win, I was inspired by the stories and concerns of everyone I spoke to keep looking for a way to serve my community. I want to serve on the county commission because there are many issues that our county is dealing with that I want to help find solutions to, especially because it will be my generation that will live in the future that our nation, state, and local government are creating. We have to find a way to keep the quality up and costs down for building new schools across the county. We need to focus on improving our roads, public transportation included, to reduce congestion and accidents. We need to find sustainable alternatives to our landfill crisis. We cannot just keep kicking the can down the road. We need to continue to encourage growth in our community, but also ensure that we retain our rural character. I can't wait to help tackle these issues and many more that challenge our community. As Winston Churchill said, we make a living by what we get. We make a life by what we give. Thank you, and it would be an honor to serve.
Thank you, Mr. Thomas. At this time, we'll open the floor up for some questions. Commissioner Pete.
Well, I did have a question. We'll start in reverse order there.
Okay.
One of my biggest concerns is education, and I'd like to know what your thoughts are on vouchers and privatizing public schools.
I'm a public school guy. Like I said, I graduated from Smyrna High School, graduated from MTSU. I believe that we need to focus on what we can do to make public school better, where the funding needs to be. I don't believe in taking money away from a public institution to support a private institution. If you want to be private, that's fine, but you got to raise your own money. That's the whole point.
Thank you.
Yes, my son goes to Browns Chapel in Rutherford County, and Rutherford County has some of the best schools across, in my opinion, the nation. But I think, just like Mr. Thomas said, keep focusing on what makes these schools great and continue that work.
I am a retired teacher, and so therefore public education is very near and dear to my heart. And I am so proud of what the County Commission and what the school board has done here in Rutherford County to continue with strong schools. And I feel like that is a good use of our money and our tax money for what we're doing in public education right now.
Thank you. Thank all three of you.
Yes, thank you. Anyone else? Okay, at this time, the chair will take a motion.
Mr. Chairman,
Yes, sir.
I move that we forward all 4 applicants to the full commission for their selection.
Okay. Is there a second for Mr. McAdoo? Any discussion on that motion?
Personally, I feel like we ought to decide here, anyone can be nominated from the floor. So if somebody wanted a different applicant than what we chose, that would be open to them. So I feel like it's our job to choose an applicant.
Okay.
So,
Yeah, I guess I tend to lean a little bit with what Commissioner Pease saying. If this was, you stripped away the county commission title and this was for an appointment to committee, we would come out of this committee with a recommendation on an applicant for the commission. And that was, I guess the alternative to that would be is if somebody felt like they were not happy with our single nomination, they could nominate someone from the floor again. But I would probably vote against the motion to move it to the commission floor and vote to bring a nominee forward from the committee. I feel in this instance, it's probably our responsibility. I certainly understand, I think where Commissioner Johnson's coming from to give everybody an option, but I tend to lean on Commissioner Peace side. I think we need to have someone come out from here tonight.
Okay. Commissioner McAdoo?
I probably would think that if it was under other situation or something, but the commissioner that we have from the 19th district that resigned or whatever wasn't under any scrutiny to do this. And I think it's very, very important that we hear from him because he was elected for District 19 and we have not heard anything from him. If he had a record or something, you see what I'm saying? I probably wouldn't go with it, but if he may have a recommendation or whatever, and I think the full commission should be able to hear it. That's my
Are you talking about Commissioner Kaplan?
Kaplan, yes, sir.
Mr. Chairman, my rationale is that this is representing the 19th district, so I feel like that this will give the citizens in the 19th district an opportunity to contact the commissioners and make a recommendation or voice their opinion or et cetera.
Yes.
Yeah, so that's my rationale.
Okay. Anyone else? Okay, I'm going to ask the clerk to call the roll for this. And this is a motion to send the full slate to the full commission, is that correct?
Commissioner Johnson?
Yes.
Commissioner McAdoo?
Yes.
Commissioner P?
No.
Commissioner Stevens?
No.
Commissioner Turner?
No.
Commissioner Gooch?
No.
4 to 2 noes.
Okay, we will take a motion at this time.
I move that we nominate all four, vote for one.
Second.
Okay, we have a motion to vote, select all four, vote for one. All in favor of that, please say aye.
Aye.
Opposed? Motion passes. Any discussion before we proceed?
Just one thing, I would like to thank all four for putting their names out. Sometimes it's thankless enough being an elected official, but really to put your name out as budget process is starting and some of those decisions are coming up. We've got a lot of good people in this county, so thank you to all four for allowing your names to be submitted and serve your county again. Very much appreciated.
Yes. Okay, when you're ready, Becky, please call the roll.
Commissioner Johnson?
Mr. Lyles?
Commissioner McAdoo?
Laws.
Commissioner P?
Ely.
Commissioner Stevens?
Ely.
Commissioner Turner?
Lyles.
Commissioner Gooch?
Mrs. Ely.
It's 3 to 3.
Mr. Chairman?
Yes.
I interject something.
Yes.
Last time we had a commissioner vacancy, the exact same thing happened. We ended up sending 2 people to the commission's board to make the vote. We did the same thing in steering. We made a decision and it came up a tie for 2 people and we sent those 2 forward, if I'm remembering correctly, and I think I am. So I would suggest we do that unless you want to, we've got something else.
Well, at this time, I'm assuming that you're making a motion to send Mrs. Ely and Mr. Lyles' name to the full commission.
I'll make that motion.
Okay, is there a second?
Second.
Okay, all in favor, please say aye. Aye. Opposed? Okay, at this time, motion carries. Mrs. Ely and Mr. Lyles, your name will be submitted to the full commission, which will be not this Thursday, but the following Thursday. Ms. Thomas, Ms. Gregory, thank you so much for your application. We appreciate you. Okay, next on our agenda is appointment of the Judicial Commissioner, Mrs. Rhonda Campbell, and I'll take a motion to send that to the full commission.
Make a motion to send the nomination to the full commission for the reappointment.
Reappointment. Is there a second?
Second.
All in favor, please say aye. Aye. Motion passes. We need to announce 3 vacancies on the Linebaugh Library Board. The current seat is held by Ms. Christy Lee of Smyrna, who has served 3 terms and is not eligible for reappointment. Marcy Lehman, Neagleville Rep, and Mrs. Joyce Seeley. We need to announce a vacancy on the Stones River Regional Library Board, seat held by Mr. Phil Griffin. Also, the next item on our agenda is the public records policy. Is that being presented by Mr. Brown?
I'm not sure if one of these is loaded on your machine there. There have been some changes made to it as recently as today, so I want to make sure that you have the most recent one. So I'm going to pass these around just to be sure. And these are the attachments. You see some forms referenced in there. That's Form 1, that's Form 2. Actually, where's the, this last time I was here, I think I kept one.
What do you need?
I thought I passed my copy out, but I've got it here.
Oh, thank you.
Okay, so what you've got in front of you is this. The open records statutes were amended to require that all governmental entities adopt a public records policy to be effective by July 1, 2017. And so this is that effort. In connection with that statute, the Open Records Council was asked to put forward a form that people could rely upon and create kind of a safe harbor if you followed the form. And then CTAS put out some model information as well. So this policy is based upon the Open Records Council form and the advice and counsel from CTAS as well, and then obviously adapted to meet our needs. I won't read all this to you, but I am going to bring up a couple of points that are worthy of bringing to your attention. The way, first of all, let me talk about big picture. The way this would work is that there is an open records coordinator that has to be identified for each governmental entity. So in this policy, that would be the HR director. In general, for open records requests that are to what I'll call county general, those requests would ordinarily go to the HR director. She would then get the initial request, and she would determine which department or office has the records in question and would coordinate then obtaining those records for the requestor. That's the overall kind of view of the way this works. What complicates it a little bit for counties, and not just us, any county, is the fact that we have elected officials and so forth that have their own offices and they have the right to adopt their own policies in their own offices. Several of our elected officials, I sent out some communication to them some time back, letting them know that this was happening and that we needed to try to coordinate how it would work and whether or not they wanted to adopt their own policies. Several of them responded saying they did want to have their own internal policy. As to those public officials that want to have their own policy, they can adopt that internally. It does not require county commission approval. There is a process whereby a elected official can present their own policy to you, not for approval per se, but for knowledge, putting you on notice. And if that happens, then when this gets passed, it would also wind up in the county clerk's office. So my point in this is if an elected official has their own internal policy and they bring it to you and it goes to the county commission, you're not approving it. It doesn't require your approval. They're bringing it to your attention, and by having done that and going through the county commission process, it'll wind up in the records at the county clerk's office. So it'll be quote-unquote, a public record by having done that. And I think CTAS thinks that is a worthwhile process for those elected officials, but it's not a required process. So here's why I'm telling you that. If you go down several paragraphs, the last paragraph right above definitions on page 1, you will see several offices that are electing to have their own policy. So the Rutherford County Property Assessor, the Register of Deeds, and I believe she's here, I think I saw her walk in, will have her own policy. The county clerk wants to have her own policy. The clerk and master, the circuit court clerk, and the other clerks of court that you see listed here will have their own policy. So if a records request is made, if someone wants an open record and it is, for example, a record that the Register of Deeds would have, rather than going to Sonia Stevenson to initiate that process, they would go to the Register of Deeds, because the Register of Deeds will have their own open records policy. On the other hand, if someone wanted a record from the finance director who was under the mayor, she would be covered by the county general policy, because she is under county general and she's not an elected official and she does not have her own separate open records policy. So there's a little bit of ferreting these things out as the requests come in, but the policy accounts for that. It is possible that, I guess, between now and next week, when the full commission considers this policy, we could have other officials that decide they want to have their own policy. But they would be free to do that. And the way this is written, it will cover any department or elected official that does not have their own policy, bottom line. So if somebody wants to have their own policy, they can. If they don't, by default, they will fall under this one, and that way everyone will be covered by July 1. All right, any questions on that part?
That's including the sheriff department?
It's including this. The sheriff's department is for now going to go under this policy. So if a records request is made at the present time, it would go to Ms. Stevenson, and she would then coordinate with the sheriff's office to obtain the records that are appropriate. He could elect, even after July 1, in theory, the sheriff's department could decide to have their own internal policy. This would not pre-permit them from doing that. And if they choose to do that and adopt an internal policy for their own office, they would just be pulled out of the county general policy. That's how that would work.
This wouldn't be set in stone.
Is not set in stone. In fact, all of these things, I wouldn't say it's not impossible that me or Ms. Stevenson could be back here at some point in time in the next 2 years saying we need to tweak this or that or change this or that. I don't anticipate that, but it certainly could happen. This is a new policy, and as we get into it, figuring out how these requests are typically coming could impact the policy, and we may have to manipulate it a little bit.
Josh,
yes,
you
sir.
got any idea what this is going to cost us over what it's costing us now?
Cost to implement the policy?
Cost to the county, yeah.
Shouldn't cost anything. Mm-mm. So what will happen?
Well, it costs us something in time and labor when somebody puts in a request.
It does.
Fills out this form, we've got to go chase that down with labor to do that.
You're right.
That's what I'm getting at.
Yeah.
We still have some ability to charge for this, just like we do now. And these two forms that he's given you, that second one indicates that, that we can determine a rational and reasonable, there are some guidelines on that, but we do have that ability, and we do charge them.
Well, and we may have to, that's my whole point. I mean, I remember, when the state came down and said, well, we've got to put plastic barriers around every lot that's going out here. We actually had to hire another person to make sure that was being done.
Right.
I want to make sure we've got people in place to do this, and we've got a way to pay for it.
And there are charges that can be assessed. If you go to page 6, Article 6, it specifies the price per page, depending on black and white or color, and also recognizes that if you have labor that exceeds 1 hour, it can be charged. And that's all consistent with the Open Records Council guidance. So the Open Records Council also puts out a schedule of fees that if you adopt are presumed reasonable, so that 15 cents a page and so forth, that's where that comes from.
Well, if you're just viewing it, though, it's still not going to cost the public anything.
That's correct.
Under our policy, I assume that the elected officials could come up with a policy where they could charge for that. I don't know.
You ordinarily cannot charge for viewing. You could charge if it took, I guess, hours and hours to get the documents together for the viewing, but the actual just viewing you can't charge for. You also can prohibit the taking of pictures with cell phones and things like that, because people do that a lot now. They come in and they want to look at something, and instead of paying for a copy, they take a picture of it with their phone. That is actually prohibited in this policy. So people can't come in and just electronically record data on their own devices.
So, Josh, basically the bottom line is that this policy would cover everyone under the umbrella of the county mayor, unless somebody else requested carte blanche, so to speak. But they still would have the option, just like Mr. McAdoo said about the sheriff's department, if they change their mind, they could withdraw
Right.
from this policy. But basically, it would be what was under the umbrella of the county mayor's office. Is that correct?
I think you said it.
Okay,
Pretty clear.
that's the bottom line.
That is
Basically.
the bottom line. Yeah.
Are most records online anyway? A lot, or?
I mean, there are some records online, but I don't know if I would say most records are online. I mean, to my knowledge, you know, Ms. Stevenson has a lot of, she fields a lot of these already. That's one of the reasons I think she's a good person to be the coordinator for this. She gets a lot of them because she's got personnel files, and that's where a lot of the requests are. They are around personnel files and things like that. So she has a lot of experience with them, and of course none of that's online. There are things that are online, depending on what somebody's looking for, like the ethics policy that we might talk about, for example, is online. And there are other things kind of like that that are online, that aren't records of individuals. Let's see, I was going to mention one or two other things. I just mentioned the fact that you can't take photographs of records. That's in Article 5D. You'll see that on page 6. I was also going to mention the copy charges, which I just mentioned, and that's on page 6. Sometimes people want records transferred electronically, and the Open Records Council guidance is that if the record is already stored electronically, and all you're doing is moving it to a flash drive, for example, then you can charge for the flash drive, but you're not charging a copy charge. So if it was 200 pages that you're moving digitally from the machine onto a flash drive, you're not charging for 200 copies because you didn't actually copy it. You're just moving the digital data from one source to another, and then you can charge for the flash drive or whatever the device is that they're moving it from. Most of the time, you have 7 days to respond to an open records request. There are times it takes longer, either for redaction purposes, or it can take longer sometimes to just get the documents together. The forms that I passed out would be the forms used for these purposes. So the first form you see is the public records request form. Ordinarily, you would have somebody that wants a document, they come in, they say you make sure that they're a citizen of the state of Tennessee, which is a requirement under the Open Records Act, and they identify what it is they're wanting. It's got to be identified with enough specificity that you can figure out what it is they want, and they can't require the government to create a document. They have to be asking for a document that exists, but if they fill all that out, then it would go to the coordinator. The coordinator would determine where that document is and go locate it. They also, if it's going to, they can ask for an estimate of charges. So if somebody made a request, it's going to require a lot of time. they can ask the open records coordinator, or if it's somebody who's got their own policy, they can ask them to give an estimate of the charge associated with it, and that person is entitled to that estimate before the copies are made and before they incur the cost. The response form is the other document that you see, and this is what would come from the records custodian or the coordinator, which, I mean, it's pretty self-explanatory, but if there's a denial of the request for some reason, this is supposed to be given to the person explaining the reason for the denial. You'll see that part way down. And so, it's not enough detail, it doesn't exist, and so forth, as to why a denial might have been given. You also see here that this form can be used if there's going to be a delay in providing the open record. Toward the bottom, we can't, we're trying to figure out, it says if we've got them, or we're still trying to retrieve those documents, then the government can give the requestor this document explaining what the delay is. All right, so that's an overview. Does anybody have any questions based on that?
I have one more
Yes,
question
sir.
on page 6, about the fees and charges for copies.
Yep,
Number 3 says labor when time exceeds 1 hour.
right.
Is there any stipulation, you were talking about the viewing, et cetera, would there be any stipulation that they could charge if it requires more than an hour's labor for them to compile all this information for them to look at?
Yes, I think
Would there
they
be
can.
something there that, 'cause time is money and money is time?
Right, and the labor charge is related to the amount of time that the government spends getting the documents together. So even if the
Regardless
person...
of whether there's copies made or just for viewing, either one, would that be right?
Right,
Okay. Because it could become kind of labor intensified,
it does at times, and you'll see also over here at the back, I wasn't going to mention this, but I will since you're asking, the aggregation of frequent multiple requests. So this sometimes happens too, where you'll have, say, an organization that's wanting records. And so they ask for a few records one day, and then, a few days later, they ask for a few more records, and a few days later, they ask for a few more records.
It's where the will
And so forth. Yeah, well, the law allows those requests to be aggregated, and that could matter, for example, if the charges are low, like let's say they just ask for 4 pages, and they come in every day and ask for 4 pages. Well, at some point, the government can say, well, it's the same requestor asking for the same stuff on the same topic, and they can aggregate those requests. And that way, if they spend a little time on day 1, a little time on day 2, and a little time on day 3, and a little time and so forth, they can aggregate their time for purposes of the labor charge. If you do that, the coordinator has to advise the person that that it will be aggregated, but they can then do that to try to prevent somebody coming in all the time asking for records on the same topic and trying to spread it out so they never get a labor charge.
Basically the same situation. Attorney advice when he's working on the case, when he's making a call, he's charging for that time. So
Right.
basically the same scenario.
Yep, just charge them for your time, that's right.
How do you calculate the labor cost?
Yeah, I didn't define that in here, but there is some guidance from the Open Records Council on that, and it's based upon it's based on the wage of the employee that's involved. You actually do the math. So you figure out the employee that's involved doing the work, and you actually figure out an hourly rate, and that's how you determine it. There's some whole separate guidance on that that is sort of beyond putting all of it into this policy. But that's how you do it.
And is that a statute?
No, that is a policy statement from the Open Records Council in Nashville as to exactly how, the statute does mention labor. I'm not answering your question very good. The statute mentions labor, but there is a subsequently issued guidance, policy guidance from the Open Records Council that spells out in more detail how you do that calculation. Let me answer it that way.
should we reference that in the document so somebody's not?
For how to do the labor charge? We could. We could.
Instead of spelling it all out, just reference what you're talking about, and that way, if they want to go and look it up themselves, all they have to do is go to the Office of Open Records.
We could do that, sure. I can make that change before the meeting.
Josh, is there any language in here that says that we're not responsible for creating records? In other words, records have information. And if they want to know what the total is for the number of hours we've spent on such and such and such, it's not our responsibility to add all these hours up for them.
Yeah, I'm not sure it says it that way in here, Mayor, specifically.
It may be in this Open Records Council
What it-
discussion as well.
Well, I think it is within the definition of a public record. So by definition, a public record is a record that exists as opposed to a record that is created.
Right.
So I think it is indirectly inside the definition on page 2B. But in terms of saying specifically, we don't have to create something, I don't know that it says it the way you said
Maybe we don't have to say
it.
that or need to, okay.
Do you need a vote from us to send this to the full commission
I think so.
with the changes?
Heather, do you want yours attached? So I think before, when it goes to the full commission, I think that there may be certainly the Register of Deeds here who wants to have her sent forward so that it winds up in the county clerk's office. And it may be that will be one or two others that are elected officials that are developing their own internal policy that may want to bring it forward to at the county commission level. I don't think it has to go through steering anyway, but I'm just advising you. That may happen when it shows up at the county commission floor. We have a couple of these elected official ones behind it. Again, not that you're approving, but that is being presented for evidence that they in fact have their policy in place before July 1, and so it winds up in the records at the county clerk's office. And I know Heather's is
What would be an
ready.
example of a difference in policy? Why would,
Why would they have a different policy? Is that your question?
what would be an example of how it would be different?
Well, for example, I'll use the Register of Deeds as an example because we work together to develop hers. It's very similar. I mean, in terms of substance, it's very similar. It needs to be because you want it to be very similar to the format promulgated so that you have the safe harbor. The rationale for why you would do that is that some of these offices get a lot of open records requests directly. So she's getting, people are coming in there for deeds and so forth. Well, that's sort of confusing because they are public records, but she's recording those and giving out copies as part of her duties as the Register of Deeds.
Right.
It's not exactly an open records request in the traditional sense of things. So as opposed to people thinking that if they want a deed, that, for example, they go to Sonia Stevenson, it just makes a lot more sense for some of these folks to have their own internal policy. And then if someone's looking for something for the Register of Deeds, instead of running that in circles through the HR department, and if they call the HR department, they just say, you just need to call the Register of Deeds.
Right.
And then she's got her own policy, she's her own records custodian, she can deal with
So
it
she's
directly.
able to do that.
It's much more efficient with some of these folks. But like the highway department, people are asking him a lot for records, but when I contacted him, he said, I'll just go under county general. So it just depends, what kind of operation they've got and whether or not it makes sense for efficiency's sake for them to have their own policy.
It kind of helps simplify the matter too for the individual to have their policy. You think?
In some of these instances, I think it definitely
Yeah.
can, yeah. Yeah.
So do we need to get your policy and send that on tonight?
I have copies for you if you'd like.
What do we need to do that also, Josh?
I think all you need to do is have a motion to send
You
this
don't need to
policy,
approve hers.
yeah,
Just send this on.
send this policy forward as amended, so.
And this
we've got-
gives her the right to,
Yeah. And she just tells Vicki or anyone else that wishes to that she wants that on the agenda, and it gets put on the agenda, and it's just submitted for your review and acknowledgement that she is so prepared that and given over to you for records to be kept. She has that policy.
okay, cool. So do we have a motion on this policy?
So moved, Mr. Chairman.
All right, is there a second?
Second.
Any further discussion?
Excuse me, one little question. Was there going to be an addendum to that or?
Yeah, it was as modified. I
As
think the-
modified?
I mean, it's up to you all, but I understood that we would add a reference to the guidance from the Open Records Council on the method of calculating labor charges.
Josh, this may be in the statute, but school board hasn't been mentioned. Are they exempt from this actual statute already by?
No, they have, but they're not under county general. I mean, they're not under us in general, so they'll have their own policy.
Will they submit?
No,
They will not even submit a policy?
I do not think they will be submitting a
put in
policy.
the record.
Right.
Okay. So, thank you.
Thank you, Mayor. Okay, no further discussion. All in favor, please say aye.
Aye.
Opposed? Motion passes. Litigation list. You got a litigation list for us?
I do.
Okay.
I hope it's on your,
It is-
All right. It should be loaded.
It is loaded.
I updated the litigation list.
All right, let me load this real quick. Okay. Is this just for our review, or are there any comments?
You know, I mean, I think it's typically for your review. I will tell you there have been some items. The only new items since last month are 3 pause matters. So a couple of at-large dog cases. You'll see several moved to the resolved section. So the Dowdy case there you see on page 7 was resolved by summary judgment in favor of the county just over 30 days ago, and there was no appeal. We tried the Hughes case on April 10, and the plaintiffs got no recovery. We got a defense verdict. The appeal period has not expired, but I suspect based on the ruling there won't be one. I could be wrong, but I think that's resolved. This next one I moved to the resolved. I had it on the list previously. It perhaps shouldn't have been on the list because actually the county was dismissed some months back from this lawsuit, but I left it on there so that you would be aware of it. But as I went back through the list, I thought, well, we were actually dismissed from this some time back, so I'm going to move it here, and then I'll probably just roll it off the list. And then several of these pause cases were resolved over the last 30 days as well. Those are the primary changes.
Is this on the shared drive, Josh, where other commissioners that are on steering can look at that too?
I think
Or
I
is
said
that-
to the mayor, Vicki, I
Well,
don't
it's
know
out there where
exactly
they
how she
could
did
get to
it.
it. Yes, I think it's,
Yeah, just because if I was one of the other ones that are not on steering, I would want to look at that too. Just
can they get it that back in?
okay.
Since we put it on here, it's there. Okay.
All right, perfect.
Okay.
Thank you.
Any questions for Ms. McCrary for the litigation list? If not, we do have one item under other business. I'll call on Vice Chair Turner.
Okay, thank you, Mr. Chairman. So I talked to Josh last week or the week before, and I appreciate Chairman Gooch giving me some time to address this. Commissioner P is already well aware of this. Scott is aware of this because I'm going to mention him by name in his organization too. So Commissioner P, Commissioner Allen, myself, Ms. Ely, and Mr. Beatty serve on the County Ethics Committee. And part of the challenge that we've been having, probably for the better part of the last couple of years outside of 1 or 2 instances, is anytime someone files an ethics complaint, most of the time they don't even show up now to argue their position or mention why they're filing an ethics complaint. And so we've got an accusation out there against somebody who has to defend themselves, and they don't get to face the person that's making that accusation against them. And I've got a huge problem with that. And I told Scott that because with Commissioner Jordan the other day, the D&J ran a front page article that had Commissioner Gordon under ethics complaint. And we found nothing that indicated that Commissioner Jordan had done anything wrong in violation of either the ethics complaint or anything that was being accused of him by what was listed from the individuals that filed the complaint. But on top of that, there were 3 or 4 people that filed the complaint, and none of them showed up that we could ask questions. So Commissioner Jordan has to take time away from his day to show up to defend himself against a group of people that didn't even have the courtesy to show up and face him face to face. And this has happened multiple times. I certainly don't want to speak for Commissioner P, but he mentioned, I think he feels the same way, and I think most people on the ethics committee feel the same way. And what I wanted to talk to Josh about was, I called Scott, in fact, the next day and said, I'm hoping you guys do a full page, front page announcement that Commissioner Jordan was found not be in violation of any ethics situation or complaint. And if I need to go to Scott's boss or editor, then I'd like to do that to get the same sort of attention to that, the fact that we're in a society now that all you have to do is throw something out, and if that sticks, it doesn't matter if it's true or not. People run with it and say, well, something's wrong there because somebody made an accusation. And that's just patently unfair and wrong, and I don't think that's right at all. So I wanted to talk to Josh to see if there was a way for the ethics committee to list in our policy or figure out a way that we could say, if you do file a complaint, at least one member of that party that files that complaint has to be present at that committee hearing, ethics committee hearing, because Chairman Beatty is our chairman. He gives them all of the information when to show up, the time will show up, where they need to be. Everything is presented to them. And for them to not show up, I think, is just blatant disrespect for making an accusation against somebody that ultimately is found to be not true. Commissioner P, I don't know if you want to add to that. You've been through it just as long, if not longer, than I have. And I hope I covered it adequately. If not, I want him to be able to chime in there. But that's where we are as an ethics committee, at least I am.
Yeah. Well, I think you did an excellent job of explaining it. To me, too, it's very frustrating when you've got accusations made, and of course the ones about Commissioner Jordan are frustrating because none of that would have came about had those people picked up the telephone and called Will and asked him. They would have found out immediately there was no conflict there. And I've seen several cases where someone makes an accusation and they have no proof. You know, one of the first things I'm going to ask you, if you come up here in front of me with an ethics complaint against an individual, I'm going to say, show me your proof. Well, I don't have any. I just heard this. You know, that's very frustrating to be able to have somebody make an accusation against somebody on hearsay. And to me, maybe that's something should be addressed too. That, you know, show me the proof. I'm not from Missouri, but you know, show me.
Do we have, to circle that back, I think that was the 2 things we wanted to know about Josh in better detail is, number 1, can we change our ethics policy to say if you do make an ethics violation filing that at least one person has to be there to represent their portion of that? Number 2, what's our investigative ability to look into that to say, well, show me your proof so we know what you're talking about, or force someone to do that where we're not just basing it off of, well, they filed it and we have no evidence of wrongdoing. What are our options on those 2 things?
All right, so I looked at this a little bit. I'm going to go backwards just for a second, and then I'll bring it forward and answer your question more directly. The law that was passed in 2006 is what required counties to have an ethics policy to begin with. Those statutes, 817-101 and several following, are set out those requirements. But all those statutes actually required was that you adopt an ethics policy that addressed certain items, namely gifts and conflicts, with respect to officials. It did not require the establishment of an ethics committee. Statute did not require that. The CTAS policies that were put out at about that time suggested an ethics committee for purposes of creating a method to deal with ethics complaints. And so, of course, the county did that and has had the ethics committee since then. I mention that because the statutes don't really say anything about what the ethics committee can or cannot do in terms of its functioning internally. So we can't look to the law, to 817-101 and following, to determine exactly how you deal with an ethics complaint. Having said that, because the policy we adopted sets up the ethics committee, I think, can internally set its own policies. You could pass some bylaws or some procedural policies for the ethics committee that the ethics committee would follow. And one of those could be that the person filing the complaint's got to show up, or you dismiss it. So I think you're open to doing that. Theoretically, I think the county commission could amend the ethics policy itself to include something like that, but my preference would be that the ethics committee deal with it internally. And I say that because, kind of like this open records policy we just dealt with, when the law sets up these safe havens and says you got to do something and here's the way to do it, the safest thing to do is follow that methodology. And by changing our ethics policy itself to say you've got to show up would be different than those models that were put out in 2006, 2007. So my preference would be that we keep our policy itself as it is, and the ethics committee convene and adopt rules, procedures, policies, and so forth. One of those could be that you've got to show up, and you could perhaps address other things in those bylaws as well, such as, the complainer bearing the burden of proof, or something. Mm-hmm. We assume that, but it doesn't really say that anywhere. It doesn't say that in the policy now. Yeah. So you could create some rules like that.
Right. That's very helpful. Again, it goes back, Josh, what I'm concerned about is when you start attacking somebody's character and integrity with no proof and no real, I don't want to say punishment, but recourse for, right, responsibility there, that I think needs to be addressed. And that's happened. I think probably 3 of the last 4 ethics committee complaints that we've received had to do with commissioners and their integrity, and the individuals didn't show up that made the accusation. So by the time it hits the paper and all that, I think Commissioner Jordan had even mentioned, his family was being asked questions about it. His children were the ones telling him what was being said. That's a terrible way to live your life with no proof of wrongdoing. And that's very helpful. And so I don't know, if we would, Commissioner P or myself or Ms. Ely can, reach out to Chairman Beatty and say, can we have a standalone ethics committee meeting just to go over our bylaws? I would like to do that because I don't want to be it could be me next.
Right.
I don't know, it could be any of us. I would hope it's not me.
Well, unfortunately, 2 things you mentioned that I'll respond to. One is there probably really is no recourse. In other words, if someone files the complaint, even that's baseless, there's nothing in the law that would allow you to assess a fee.
Right, sure.
So there's nothing there. The other problem is if your policy is that you dismiss it if they don't show at the meeting, the newspaper artists are already run.
Yeah, but it's still, that doesn't remove inaction, non-action on our part. I mean, we've got to figure out a way to, say, hey, everyone is welcome to file this, but you do have a responsibility when you do file to provide some proof or be there to represent what you're filing against. And that's the big motivation there. So we can, take that offline with Chairman Beatty and say, we'd like to meet next week, 2 weeks, whenever. But I just think it's something that we felt as an ethics committee, because, we all left our jobs to get here for the meeting, and I'm driving from Nashville, and, Mr. P's driving from his house, and Ms. Ely's from hers, and there's some common courtesy there too, not to just throw something out there and then think, well, I don't have to answer for this. We're not trying to put you on trial, but if you are going to accuse somebody else, you need to be able to provide some evidence and information about why you're doing that and why it's serious enough to file a complaint, so.
Well, I'm confident in saying that the Ethics Committee can create some procedures around that
Good.
process.
Perfect. Thank you.
Can the person be put under oath that files the complaint when they present their evidence?
There's nothing in the statute that says you couldn't do that. I think that's something that the Ethics Committee could consider. I mean, again, you're into a little bit of developing your own policies without a ton of guidance. Because when you look at the law, it doesn't even require the creation of the committee. So inherently, once a committee is created, I think that committee can create its own rules to govern its processes. And there may be a lot of things you could work in there that might make sense. I don't know if that does or doesn't, but you perhaps could do that.
Josh, I just want to sort of emphasize, the Ethics Committee is set up and it has a very narrow ability for those things that rise to the level that you can find somebody, quote, guilty. Financial impropriety or conflict of interest, et cetera, that does generate some individual benefit for the person that these complaints have been filed about, is about all you've got that people can be held accountable for. Is that, I just want to be sure that's sort of a fair statement.
I think that is very fair. It is not a receptacle for the presentation of every grievance about everything that happens in county government. It is very narrow.
I will say that early on, there were certain ethics complaints that were filed that were absolutely clearly not something that had anything that rose to the level that we just mentioned here, and they were dismissed without even an ethics committee meeting. I think the chairperson consulted with our attorney and probably told you people that, in his judgment, that wasn't necessary and it didn't happen. So they didn't actually have a meeting.
Yeah, he has done that, but you get my point
Yes.
about you can't just go around accusing people
Absolutely.
of stuff. That's just not a good look.
Do we have a standard form that they fill out when they file their grievance?
I think the
Yeah, it's a
committee
document that
has
he
a form, yeah.
he fills out, and then they submit it, and then Chairman Beatty or Vicky or someone will send out a note to us saying there's been an ethics complaint filed, prevent that or provide information, and then we make a decision on.
I think
if
it's
we-
presently written that, as the mayor says, there have been instances where the chairman receives that and looks at it and just says, we don't even have jurisdiction to convene on this. It has nothing to do with what's inside the scope of our ethics policy, and he may reject jurisdiction from the outset. Another good thing, though, maybe that could be addressed in some bylaws is some clarity around that process, where the chairman has the authority to do that. Maybe there's a time period for responding and declining jurisdiction and explaining why, or some things like that that might be helpful.
Could you meet with us too, Josh, on that? If we
Yep.
set that up, I'd love to
Sure.
have you there to
Yeah, no problem.
steer us up.
You can meet with
Thanks for
Where I was going with
answering.
the application,
Yeah.
and they have to have it notarized, and they swear under oath that these facts are true, and if it turned out that it's not, they could be prosecuted for perjury. And that really, I think that really would up the
ante.
seriousness
Yeah.
of it.
Okay, so we're just going to leave it up
Thank
to the
you.
ethics
Yeah.
committee to meet and have
Thank you.
Appreciate it, Chairman.
do that. If they change something, it doesn't have to come to us.
Not if they only do it internally
It's
as
got
a,
with-
as a bylaw.
All right.
Not-
Any further business? If not, this meeting stands adjourned.
Thanks, Greg.